Welcome, Volodymyr, at the second stage of our selection to the High Qualification Commission of Judges. Good morning, dear members of the Commission. So, the Commission is conducting the interview in its full composition. That's Zajachny, Ivan Mishchenko, Yevhen Mezentsov, Sergei Verlanov, Stephen Markman, and Robert Brugheisen. The rapporteurs at your interview are Yevhen Mezentsov and Tats Zajachny. If for any reasons our interview is interrupted, we will reach you and reschedule the interview, and we'll start it with the place when it is interrupted, in case this happens. The members of the Commission will ask you questions, and please, our request is that you give concise answers to the core of the matter, and the member of the Commission can limit the time of your answer. Before the beginning of the interview, you will have a chance to present yourself, your ideas, your vision, and the most important thing, your motivation for participation in the selection process. So let me give the floor to my colleagues. Yevhen, you're welcome. Thank you, Mr. Chairman. Good morning, Volodymyr. I'm Yevhen Mezentsov, and it's an honor for me to start communicating with you and make the introduction to our interview. So with your permission, before we go over to your introductory speech, for our observers, for the audience, I would like to mention a couple of words about you for you to understand whom they are dealing with. So our today's candidate is Volodymyr Rysenko, born in 1971. He has graduated from the National Yaroslav Mudry Legal Academy in 1996. He's got the certificate of the fluent command of the Ukrainian language of the second degree, issued in 2022 on the 25th of January. His work experience is 33 years, and legal work record is 27 years. He has been a practicing lawyer since 2012. Since 2005, he worked as a legal consultant, legal counselor at different enterprises, and he is rather active in his anti-corruption activity. He's provided a well-structured motivation letter. He's got some social initiatives in the city he lives in, which is Kharkiv. And as far as his property is concerned, he's got 2 apartments in Kharkiv for 32 and 81 square meters. His wife has got in joint property 63 square meters. As far as civil society organizations and NABU are concerned, there are no special remarks concerning property issues of Volodymyr. Along with that, Volodymyr is proud of the fact that he participated actively in a public activity in Kharkiv. In particular, he represented the interests of Kharkiv Anti-Corruption Center, NGO, in the case on the renaming of the Zhukov Avenue, and that was a rather successful process. And now he is a member of the NGO Kharkiv Anti-Corruption Center, and he is actively promoting this center in media, in social media, and so on. So that is my introduction, and maybe I've forgotten to mention something, and I would like to focus specifically on something about you. Please, the floor is yours. Thank you for presenting me. It's rather difficult to speak after this presentation. It's difficult to add anything, but I will try to. So first of all, let me express my gratitude to the Commission for the opportunity provided to me. Let me welcome all the audience. And let me tell a couple of words about my motivation, because this selection commission has a very ambitious goal, which is to fill more than 2,000 vacancies of judges in the courts of Ukraine, because we have staff shortage, as you all know, and to complete qualification assessment of judges, which has not been completed by the previous composition of the HQCJ. I think that this must be the most large-scale staff updating over the whole history of Ukraine, And it really depends on the composition of the HQCJ and on how it copes with the challenge, how the judiciary will function over the next 20 years. We don't know what Ukraine is going to be like in 2050, but we know that this selection of the Commission will select judges who will keep administering justice in 2050. And that's why, yes, so you're talking about the future. Yes, please. The point is that probably we don't all realize this at the moment, but that's true because people who are 35 and who are elected judges by this composition of the HQCJ will be administering justice in 2050. Besides all the other challenges, we have war, and because of that, more than 20 or 25 Ukrainians are located now in Europe. We're experiencing the most large-scale demographic crisis in Ukraine, and we need to have them back. And the trust in the judiciary, of course, has its impact on this aspect. And a similar problem is this problem that we got even before the outbreak of the full-scale war. This is the problem of lack of trust among investors to the judiciary, and we need to earn this trust in order to restore Ukraine, because without foreign investment and without having our Ukrainian citizens back, we cannot speak about restoration and rebuilding of our economy. That's why restoration, reconstruction of Ukraine and recovery of Ukraine greatly depends on the revival of trust in the judiciary. Thank you. And okay, we've got your motivation. So let us go over to things that are simple. Let's start with your motivation letter and with the statements that you make there, with the considerations you express there. As the reasons for participation in the competition. You have mentioned that you consider rule of law to be the only possible foundation for the state existence, at least existence of the state you would like to see. What exactly do you mean by the notion rule of law, in particular in the context of Ukrainian reality? Well, it's a relevant question, thank you. That's a wide question, I would say. It's rather difficult to give a concise answer to it. It's easy to answer it using the terms prescribed in the Constitution and other regulatory framework acts. But if we speak not in trivial language of law, we should say that this is the only possible option for passing any decisions in the state, because unfortunately, first of all, we have a lot of illegal practices in place, like appointment to positions on the basis of some political beliefs, dispute resolution by the judges whose independence and impartiality are doubted. But we should reach the stage when every decision, and we know that every decision and any reform and appointment or dismissal of any minister will sooner or later lead us to courts, because the minister will appeal his dismissal. And we have got a bad tradition when people are detained in public, measures are taken to detain a person, the results of the search are disclosed by the law enforcement bodies in public, but we don't know what the end of that case is. Yes, Volodymyr, but we have somehow deviated from the topic, so let me specify my question. If we take your concept, at least the one which you express in the motivation letter, the rule of law has to prevail in the relationship between the state and its citizens. And now, when decisions are passed in Ukraine, we cannot be guided just by the basic human rights, because still we have the law, not the rule of law, but the law dominating as the primary source of rights and laws and human rights. And in this context, it's rather difficult. So what do you think is better? To stop using law, applying law in favor of the rule of law, or what is meant by your concept, by this statement made in the motivation letter? Okay, clear. You know, justice and fairness in the system of justice is exercised only via the laws. We cannot be guided by the ideas about justice or fairness or some moral and ethical norms that dominate in the society or in a certain group of the society. We should be guided by the law only, because there is no other source, or there is no other foundation for our decisions, judicial decisions. We should realize this. But if we think that the law does not correspond to some ideas of a certain group of people about fairness, about justice, this group may launch a campaign to change the law, but this is not somehow related to the system of the judiciary. Prosecutors, judges, and attorneys should follow the law. We don't have any other option. We cannot measure our actions with anything else. It's just about the law. Okay, clear. Your reference letters have been provided by two representatives of the Kharkiv Anti-Corruption Center, including its founders, and one representative of the NGO Наші гроші, or Our Money. What about the range of your communication, your professional environment? Is it limited to such politicized, anti-corruption activists, or do you have any acquaintances among lawyers, prosecutors, judges, with whom you also communicate? Of course, my range of communication, Your Justice, you should probably not address me, Your Justice, here. Well, sorry, that was just a slip of the tongue. I understand that this is the habit of the lawyer. Sorry for that. I work a lot in courts, that's why I said Your Honor. And of course, it's not limited to NGO activists, but there were some objective limitations, because I wanted to ask some lawyers for reference letters when I passed my decision to apply, and I was rather quick with making this decision. So back then, they were already in the army, and I couldn't ask them for reference letters. And there were some judges who could give me reference letters, but after some hesitations, I still decided that there would be some conflict of interests. If I apply for the HQCJ, I probably shouldn't ask judges who will still have to take their qualification assessment. Would be a wrong approach. Okay, you're right with this, probably. You also mentioned in your motivation letter that you dealt with translations of decisions of the European Court of Human Rights, and you even gave some examples. From what language did you do this translation? One of the translations was from French. Yes, actually all of them were from French. One of them was from English, but actually it was not me who did this translation. But there was one decision that I myself translated from French. In your motivation, you actually state that you yourself translated it, but your level of, your command of French is just A1, which is bonsoir, and that's the only thing you can tell at that level. So does your command of the French language allow you to really do translations from French? Well, The point is that I had a very limited period of time over which I had to find some practice because there was already a court hearing approaching. The decisions which I needed didn't have any official translation of the Ministry of Justice back then. And the French translator whom I found was very busy at that time. That's why I did the translation myself. I checked it for conformity and just sent it to this French translator to check, to double check it. And somehow I would say that this translation was more official because it was checked by the official translator. Thank you, Volodymyr. We quite often try to pick with our candidates concerning Section 8 of the motivation letter, which is the key section for us. And this section determines your vision of the future functioning of the judiciary. And this section is dedicated in your motivation letter to lack of trust in the judiciary, as well as to the impact this aspect has on the investment climate of Ukraine and on the relationship between Ukraine and its partners, I mean, foreign partners. Besides having determined that the level of trust is really low and something needs to be done about this in the future. So besides this, I haven't seen any specific measures. So could you specify any measures that should promote revival of trust in the judiciary in the nearest future? Thank you for the question. Probably this is the most important both for this interview and for the overall activity of the HQCJ. I would say that there are three measures like this, at least. First of all, we need to understand that the society is a kind of a mirror reflecting in the sociological surveys the expectations and the level of trust that is available in the judiciary for the moment. This is a mirror, but a very emotional mirror, because every person is emotional, and if people are taken together, they become even more emotional. That's why any mistake, any negative action in the judiciary is reflected by that mirror as an exaggeration. Which means that if we see some violations committed by a judge, any misdemeanor, let's say a traffic accident, or a fine for a violation of traffic rules, and when we try to assess these misdemeanors by the HQCJ or the ACJ, these are the bodies of local judicial self-government, and they try to assess it, taking into account the degree of the misdemeanor and the consequences it leads to. But we should take into account that the level of trust in the judiciary actually consists of the trust in every judiciary. So every action of every judge influences the overall reputation of the judiciary. That's why the first thing that needs to be done is to make judges aware of the fact that every action has an impact on the overall reputation of the judiciary. Everyone in the judiciary should realize this. The second measure is that when decisions by the HQCJ and HCJ are passed, one of the principles, in particular in the disciplinary proceedings, should be assessment of the impact of that action on the overall reputation. Another step, which is more tedious procedure, is that we should give this mirror, the society, some positive examples. We should keep doing this all the time. We have been at war for a year, a full-scale war, but the system of the judiciary is still operating, and without this system, the state will not be able to function. I can give some specific examples. No, specific examples should not be given. Okay, so we should give positive examples to the society. Let's have a look at their High Anti-Corruption Court. It informs about every step it takes about every single decision that is passed. Let's have a look at the Supreme Court. So you mean expansion of communication, because it would have a positive effect on the level of trust? Yes. But we understand that this is a long-lasting procedure, but there is no other way to take. And the third step, which is the most difficult, I would say, is that unfortunately we don't have the practice of public court hearings. You know that in the US, judiciary has got good reputation because they have the system of these public hearings, public proceedings. They have it even in the cinematography, and they have got the so-called court drama. They are included into the judiciary. I mean, the public is always included into the judicial proceedings, and that's what the European Court of Human Rights always says, that it should be done in public. Also, we should take here training in the National School of Judges, and all judges should become aware of the fact that they should not be closed to the society, to the public, but they should invite representatives of the public, because these public hearings have shown me that there is nothing better for the reputation of the judiciary than a reasonable, well-grounded decision passed in the public hearing. So you think that live broadcast in social media, in YouTube, would also promote a revival of trust? Yes, sure. All right, thank you. And Volodymyr, let's go over to political neutrality. As far as your property is concerned, we don't have any special issues. That's why let's communicate about political neutrality, because we have some concerns in it. In particular, you mentioned that you belonged to the initiative group of Mikhailo Saakashvili's group, Movement of New Forces, in 2016. What was your role in that initiative group, and do you maintain any contacts with this movement? As for now, were you a member of this political party, the Movement of New Forces of Mikhail Saakashvili? Well, thank you. My role was rather modest. I just tried to arrange a center of this political party in Kharkiv region. I had something to do with this initiative group that was trying to kind of establish the center. But it was for a short period of time. If I'm not mistaken, I dealt with this for about a month, because some issues that we asked the leadership in Kyiv were not settled the way they should have been, as it seemed to me. That's why I actually stopped doing this. The party at that point of time was not registered as a party. That's why I was not a member of this political party. And after the party was established, I didn't maintain any contacts with it. I was not a candidate at the election, and I was not using any passive or active rights. You know, the Commission is paying attention not just to availability of any political activities, but and to the style of our candidates. Your motivational letter is written in a good style, and it's like a speech from the rostrum as a political slogan, if we have a look at its structure. That's why we are paying attention to the issue of political neutrality, because we can see that you are motivated for having some sort of political activities. That's why let me ask another question. In Kharkiv, there is Ivan Rainin, a famous politician who used to be the head of Kharkiv Regional State Administration over a period of time. And external sources actually say that Kharkiv Anti-Corruption Center is somehow related to this person. So what about your personal relationship with this politician? Do you know him personally? Did you participate in any campaigns related to him? No. I was not involved in any of the campaigns, and I didn't participate in any public events together with this man. We are not personally acquainted. And the relationship is probably connected to the fact that 2 times, if I'm not mistaken, we signed a memorandum of compliance of the Prozoro system requirements. If you allow me, I will tell you a little bit more about this. This was the memorandum with Kharkiv Regional State Administration of which Mr. Rynin was the head. So we signed this memorandum to comply the ProZorro requirements in order to improve the economic situation. It seems to me that reporters were present at that signing procedure. So the threshold in ProZorro for procurement was 200,000, and we had an agreement that for Kharkiv region that will be 50,000 hryvnias, and we saved a lot of money for the communities through this memorandum. So that's what it was. But at that time, he was the head of the regional state administration in Kharkiv. Volodymyr, you state in your motivation that you are proud of having participated in the cancelling of the name of Zhukov Avenue in Kharkiv. So, as far as involvement in this process is concerned, it's about the fight between the past and the future. What urged you to get involved and to actively participate in this process? What served as your inspiration and motivation in this context? Well, my main motivating factor was that it's public space. These are the streets we're going along, and of course, the name of the street somehow affects the mindset of the people going along them. And of course, it's one thing to write the letters about the Petro Grigorenko Avenue, who was the Crimean Tatar activist, and if you're writing letters to an institution located there, it's okay. But if you're writing letters to the institutions located in the Zhukov Avenue, and Mr. Zhukov is known as a Russian who wanted just to fight Ukrainians, and who just didn't care about Ukrainians who were killed because of his campaigns during the World War. It's a long story, but renaming was taking place within the decommunization process in 2016, if I'm not mistaken. And then after a certain period of time, the administration of Kharkiv City Council, Mr. Kernes back then, decided to get some political scoring and to rename the avenue into Zhukov Avenue again to get some score for the election. So we cancelled one decision, another decision. It was a long process. Thank you. So actually the elements of the case are not that much important for our selection commission. What was important was your motivation for this. Let me now give the floor to my colleague, co-rapporteur, Tadzarzeczny. You're welcome.
Yes, good morning, Mr. Rysenko. Mr. Rysenko, I take the information that we have been provided about you and from you to tell me that you are a mature individual in your profession. You have 26 or so years of practice experience as a lawyer, and you have taken you tell us, a very particular interest in the functioning of the judiciary and the administration of justice in Ukraine, particularly the role of judges in that administration of judges. I don't see any information that would suggest that you yourself have put forward your name or sought appointment for judicial office. Some candidates we've had the opportunity to interview have done so and therefore personally experienced participation in the work of the High Qualification Commission of Judges. Had you ever considered a judicial career and perhaps I missed some information from you. Have you ever made an application and experienced the HQCJ process?
Well, yes, I have thought about judicial career, but it was always more important for me, or I would say that I liked the work of the practicing lawyer more. I liked defending the rights of people and undertaking the cases I come to like, and to be scrupulous about the study and analysis of a specific case. That's what I like more. That's why I did not ever participate in any judicial selection processes, and this is the first competition for which I have applied for civil servant's position.
Thank you, Mr. Rysenko. And I'm sure that there are many persons like yourself who choose to continue a legal practice as opposed to a judicial role, and that is also necessary, of course, to assist the rule of law. Good, experienced lawyers are very important to the operation of the system. Let me focus a little bit on some of the activity, though, that you have had with respect to scrutinizing, if you like, the role of judges in the judicial system and administration of justice. You have participated in an NGO, and you indicate to us that you have assisted the Public Integrity Council in some of its work. And presumably that is related again to the selection of candidates for judicial appointment. What was your role and involvement with the Public Integrity Council is my first question. And secondly, what would you suggest if you are chosen to be a member of the High Qualification Commission of Judges of Ukraine, what would you suggest as the appropriate role to support the effectiveness of the PIC recommendations?
Thank you. So we need to split this question into two parts. To answer the first part of the question, I would say that I really was personally involved in the judicial selection process, because back then, when the selection was announced for the Supreme Court, and when there was selection process for the High Anti-Corruption Court of Ukraine, and generally when there was qualification assessment going on, and when some anti-corruption reform was conducted and the declarations of judges were transformed from paper version to the electronic format, we were analyzing and scrutinizing declarations in order to check whether the level of income of the candidates corresponds to their way of living. We were trying to clarify some facts from open state registers, by the way, not only registered in Ukraine, but in some foreign countries. We were establishing some facts, verifying the facts, the way we could, to the extent we could, as a public organization, using only open sources. And in case we identify some miscorrespondences, mismatches, or if vice versa, we detected that the candidate is a person of integrity, so we provided the facts to the Public Integrity Council, and in some cases to the NACP, if we could find some information. This is the experience that will help me assess candidates if I'm appointed a member of the HQCJ. As far as the Public Integrity Council is concerned and its role, it's a very important matter which is all the time discussed both in the society and during those interviews. So, I should say what I dislike about the narrative which constitutes the foundation in the relationship between the HQCJ and the PIC. The law already sets a certain conflict. The only interaction, as for now, is a negative conclusion, negative opinion of the PIC concerning some candidates. Even the state anti-corruption program, the draft program that is about to be adopted by the Cabinet of Ministers, says about the different mechanism as joint meetings of PIC and the HQCJ. I would say that there is a conflict hidden in the law now. And maybe at a certain point of time, this conflict played its negative role when it was necessary to set some standards of integrity and to establish what facts of integrity were to be identified. But of course, it's also played its positive role. But now we should deviate from this practice. The HQCJ should not perceive the PSC as the one that is providing only negative opinions. That should be a channel of communication that provides as much information about every specific judicial candidate as possible. And this information needs to be introduced into the judicial dossier and studied. And this really could help the HQCJ in its work. On the other hand, the PIC should not be perceiving the HQCJ as its opponent. They should be partners in the selection process. I think that when the new HQCJs and the new PIC start operating, they should cooperate and they should jointly work at the filling out of judicial dossiers and the collection of all the relevant information. And the path we're now taking would lead us to a dead end. I would say that still there is the conflict in the law, and this conflict cannot be settled. And if the PIC provides a negative recommendation, they want to have more and more negative recommendations because it's the only job they are supposed to do. So I think that there should be cooperation, not only in terms of negative opinions, but of course we should start this cooperation from scratch now.
Well, thank you for that answer. And that brings me to pick up an area that you discussed with Judge Mezentsev, and that is the role of lawyers in assessing, if you like, the work of judges. All too often, we hear lawyers express negative opinions about judges. Some of that is because cases were decided against the interests of their clients. In other words, they were not successful in the case, and because there is a natural tendency, I think, for lawyers to discuss judges and judges perhaps to discuss some lawyers. And you have considerable experience, you say to us, in representing clients at all levels of courts. So I'm going to invite you to share with us 2 or 3 of your observations with respect both to the positive comments that you may have about judges that you have personally experienced, and I am not interested in any names, and perhaps some, if you like, negative experiences or observations you have about the way judges have conducted themselves. And that would, of course, give us an insight as to why there may be some concerns about the judiciary as it currently exists, but there may also be some compliments. So I'll leave it to you.
Thank you for the question. Well, first of all, really, I would not better talk about any specific personalities, because when we are discussing the general situation in the judiciary, we should talk about trends and tendencies and not about specific people. One of the best trends in the current judiciary, which is also inherent in the judiciary in general and in specific judges, is among the lawyers in particular, is the following trend: adequate reasoning of every court decision. We understand that we have the problem of staff shortage and the load of judges is very high. But when you, as a lawyer, come to the court hearing, you prepare for it for several weeks. You make a file, a lawsuit, then you get ready for several weeks, several months. You seem to have studied the issue very well. But when you get the court decision, and you see that in that court decision, it's not just written that on the basis of the principles of adversarial nature, we should pass this or that decision. But if you receive the decision where the judge's independent view is set out with reference to the arguments and to the practice that none of the parties has ever presented, when you understand, and sometimes I could not even find this court reasoning, legal reasoning in the practice of any other judges. And that was just the independent view of the judge of a trial instance. So you come to realize that this judge corresponds to the principle of professional competence better than anybody else. So I think that the greatest virtue of a judge is proper reasoning of a court decision. And in this specific case, it's not important what decision has been passed. I mean, has it been in your favor or in the favor of your clients or not? Even if you lose, but you see the good reasoning behind the court decision, that, of course, makes you respect the judge. That is the positive comment. The most negative trend is inadequate reasoning of court decisions. Because in spite of great lack of judges, of a great problem of staff shortage, in spite of the fact that judges don't have much time to prepare court decisions. Anyway, judges should not only listen to the arguments of the parties, but also set out their own vision for us to see how justice is being administered. And I think that this is the most negative issue, the greatest challenge in the system. Because the worst thing is when you come to a court hearing.
Excuse me. I think I've got the point. You have answered my question. I do want to leave time for my colleagues to ask you questions as well. So I'm going to turn you over to Mr. Broekhuizen, who is a member of our commission, and I'm sure he has some questions of you as well.
Thank you, Mr. Rysenko. I'm trying to pronounce Volodymyr, so making progress, I hope. I hope you give me some concise answers, because otherwise we have indeed not suffered much time to touch to the issues I would like to discuss with you. I've listened to you carefully, and the first thing I'm wondering is, because that is not clear to me, what kind of a clients are you helping as a lawyer? Are you a litigator, or what do you do? Who are your clients? How do you make your money as a lawyer?
So for quite a period of time, I had legal entities as my client. I worked in the commercial jurisdiction.
Yeah, I've seen that, yes. Yeah. But I mean the last 10 years as a lawyer, as a professional lawyer, commercial lawyer, I guess.
Well, now, mostly, I work within civil proceedings and administrative proceedings when I'm addressed for appealing some decisions of state authorities in the administrative proceedings.
But who are your clients? Are that commercial companies, individuals, oligarchs, foreign companies?
Well, unfortunately or fortunately, I didn't have any oligarchs among my clients. Mostly these are legal entities and civil society organizations, NGOs. Because some decisions of the state authorities and local self-government authorities have been cancelled by me upon the basis of the lawsuits submitted by the natural entities and civil society organizations, NGOs.
But do you say that you live on civil society organizations' work, or is there also commercial work?
I've got both. Yes, you're right. I would say that I've got 50-50, like from NGOs and profitable activity from provision of my service, legal services, and representing the interests of individuals in courts. 50-50. I wouldn't say that I managed to survive. I just earn enough, I would say.
Okay. Have you ever experienced yourself, let's say, corruption in the courts? Have you ever been asked to pay a bribe or been involved in anything that's connected to that? Was there any judge ever who said to you, please pay me something? Or was there an attorney? So you don't have any personal experience with bribing?
No, I don't have any experience like this. No personal experience of dealing with bribery and corruption. And there can't have been any because, you know, the attorney at law, and in particular me, I have not been undertaking the proceedings where the clients could actually launch a talk like that. I just didn't take any cases like this, and that's why I don't have any personal experience of corruption as such.
But still you are an activist in the judiciary regarding corruption. So it means that you would have, I would expect to have, let's say, some idea or background or experience with corruption when you were doing your job over the years that you have been working. Because otherwise, maybe you can explain that, it's difficult for me to understand why you have become such an activist.
Well, we should probably distinguish between these two issues. Experiencing corruption, does it mean that I was a witness of certain corrupt acts? If we open any textbook on law, we will see that corruption crimes are related, are latent ones. Two people know about it. The one who gives the bribe and the ones who gets the bribe. And that's what I can tell absolutely, that I was not a witness or observing such process, because normally we don't have witnesses in such things. And it's an absolutely different thing when we see some court decisions which are not motivated, which are not reasoned, and which do not take into account certain practice of, let's say, the Supreme Court, and that have been passed counted to this practice, but there were some reasons and grounds for passing such decisions. So we may assume that there could be two grounds for such ungrounded decisions, either professional incompetence of the judge who passed the decision or some other reasons for passing this decision. And we may assume that there could have been corruption.
What you do is that you say that you analyze, let's say, judgments, and then you assume on basis of those judgments that there may have been bribery or that the people were not competent to give a proper judgment. And you say, if I summarize, that you have been reading legal books, and from those books it appears that there may have been corruption within Ukraine. But you do not have any personal experience. Is that correct?
Well, I don't belong to law enforcement bodies. When you work, let's say, at the National Anti-Corruption Bureau of Ukraine, you have personal experience because you have to take some investigative actions in relation to a specific judge against whom there has been made an accusation about illegal profiting. I can give you some sentences, some decisions that have been passed over the recent years. So in that format, I have experienced it. But you're asking me about my personal experience. I'm not an investigator, not a prosecutor. I don't belong to NABU, so I was not involved in any investigative action. That's what I mean.
Maybe I will say about these two things. In all those interviews we have been doing, I have not found anyone yet who confirmed that they had personal involvement with bribery. And sometimes it gives me a very strange feeling that we are talking about a very low level of trust, and there is no one saying to us that he has personal experience. That's the first remark I would like to make. The second remark is that in bribery and corruption, there are always two to tango. It's the receivers, it's the payers. And from my practice, I know that the payers in judicial corruption are most likely and most often, what do you think, the lawyers. So maybe you can comment on this. So how is it possible that someone who has so much experience as yourself has no contact with corruption, especially not when he is in the job, where if you are in a corrupt environment in the judiciary, it would be likely that there would have been some contact.
Let me start with the first comment. When you mentioned that you know not a single candidate said that he or she had a personal experience, but you know this is not a representative selection. I mean that the candidates are probably not the detectives of NABU who deal with corruption issues in the judiciary. If there were at least 5 candidates who are NABU detectives, they would all say that each of them had this personal experience of taking investigative actions or dealing with some indictments or sentences. And you would hear specific names and specific examples. And it seems to me that yesterday I had an interview of the candidate who is the head of the Department of Complete Vetting in the NACP, and he mentioned the number of protocols which were based on the manifestations of illegal profiting or acquisition of assets on ungrounded basis. So if a person has got ungrounded assets, and it seems to me he also mentioned the judges, this already indirectly shows that there is corruption in this specific court. The other thing, and the most important thing, is that I support the idea that all actions should be taking place only within the legal domain. Even if we get some data, some information from individuals, and this data shows that it seems to them that the judge misbehaves in this proceedings. And I always ask them, does it seem to you or do you have facts? And he said that no, it just seems to us. Are you ready to witness, to give the evidence? But they cannot give any evidence. It's difficult because it is a latent crime. And I always told them that if you have some facts, you shouldn't go to a civil society organization dealing with anti-corruption, but you should go in your specific case to the prosecutor's office, supply motions and criminal proceedings, and I can prompt you the way you can do this, but you should work only within the field of law for this crime to be recorded through the proper procedural means, and for this case to have some procedural prospects. You cannot just highlight this information in public. It would be pointless.
Okay. Well, thank you for those answers. I've only one other question on a different subject. What I understand is that you, let's say, are a NGO lawyer, let's say, working for civil society organizations. And that is the background that you bring. And it's also possibly one of the reasons that you have applied for this competition, which of course I understand. However, you will be working together with all kinds of other people within the HQCJ. Have you any idea how they will look upon you? Because you are someone who comes from NGOs, and you're someone who may believe that judges may be corrupt. So how are you going to deal with this when you are in the HQCJ and that you have to discuss every day and with your colleagues, who may be judges partly, and also with the candidates who will be judges either in office or to be selected? Will they trust you? How are you going to cooperate with them?
Well, first of all, I have perfect communication with the judges, with whom I am personally acquainted, and I wouldn't say that they don't trust me because I'm an NGO lawyer. They understand what the principles guiding my activity are. This is the first thing. Secondly, the more experience, the richer the experience that the different members of the HQCJ bring to there is. I mean that if we have scientists, researchers, lawyers, judges there, so the richer the experience, the more objective the decisions of this team are going to be, I think. Because we can have a look at any fact in any CV of any candidate from different angles. Some of us, I mean, not of us, but those who are elected, or probably my colleagues who are more successful and will become members of the HQCJ, will contribute their experience. And the more diverse this experience is, the better it is for the team. As far as interaction is concerned, starting with the point of election or appointment to the civil service position, you stop being an activist. That stage is going to be over. You start a new stage of being a civil servant, and at this stage you should perform your duties to the full, and with this in view, you need to work in a team and to work very effectively. So I think that this will not in any way prevent me from working with other members of the HQCJ, because our motivation is going to be the same: to ensure reloading of the judiciary, complete qualification assessment, and select judges for the judicial positions who are people of integrity and who are professionally competent.
Thank you.
If the selection commission chooses people with such values, I don't think there will be any problems.
Thank you. I will now pass the floor to my colleague, Justice Martin.
Mr. Rysenko, we appreciate you being involved in this competition. Thank you for that. You've indicated in your motivation that you and colleagues have spent a great deal of time analyzing the declarations of local judges and candidates and reviewing their property ownings and studying their incomes and their declarations and things of that sort. This is just a matter of curiosity. Have you shared any of that information with the Selection Commission or civil society organizations that might in turn share that information with us?
Well, we were not analyzing the candidates for this very selection because that would have been a conflict of interest if you are one of the candidates running within the same selection and you are analyzing the declarations of your competitors. Of course, we were not doing that. But as far as the selection to the High Anti-Corruption and the Supreme Court of Ukraine were concerned, yes, we did analyze the declaration of the candidates, and we shared the information with PIC for them to make their opinions, and we also shared some information with NACP when we found some assets which we believed did not meet the level of income of the candidate.
Well, please don't take this next comment wrongly, but if the conflict of interest that you've just suggested might have been raised there, would there have been a case for you looking at what arguably would have been the greater public interest in sharing the information with the Selection Commission and civil society than pursuing your private interest, wherein there would have been no conflict of interest?
That's a good question. Well, if I happened to come across information that in this or that way tells me about any lack of integrity that a candidate may have, a candidate that has already reached a certain stage in the selection. Let's say we are talking about this very selection, then maybe I would do that in public and I would report to relevant authorities. But again, this is a conflict of whether I'm going to pursue my own interest or the interest of the society. This is going to be a difficult choice for me, and I'm being honest here.
No, I appreciate that. I understand it's a difficult choice, and I also understand you're being honest. Thank you. Let me pursue the inquiries that my colleague, Mr. Brookhuizen, has just raised with you. Explain to me again, what is an oligarch? I'm, of course, familiar with the term. I've heard it most of my life, but I've heard a lot more about it since I've been here in Ukraine involved with the Selection Commission. What is an oligarch, and what should one make of oligarchs having some influence in the judicial process?
The thing is that according to Ukrainian legislation and general understanding, an oligarch is not just some big businessman. It's a businessman who uses their money that they earned either legally or illegally. Let's not discuss that, but in Ukraine, there's this difference between a businessman and oligarch. But if we are talking about their assets, it means that they are using them to have influence either in the political sphere by funding some politicians, or in the history of Ukraine, we've had these cases when an oligarch created a political party without any other sources of funding, and that party got votes during the elections, and their faction in the parliament was quite big. And after the oligarch bought the political influence, they moved on to media influence. It's not a secret that the majority of our TV channels did not get any profit, and they were funded solely by their owners, the oligarchs. So the oligarchs use their political and media influence in order to have specific people appointed for government office. And this combination of influence plus great assets, the ability to influence who will be appointed to this or that position, that's what makes an oligarch. That's what we call an economy created by oligarchs. And the war interrupted all of these processes, but let's see what will happen after the war is over.
And often the influence of the oligarch would be accomplished indirectly, is that correct? Through other individuals and organizations. Is that a fair statement?
Yes, yes, of course.
And it's appropriate that...
Yes, that's actually what's happening.
And it's appropriate that this selection commission should work hard to it's appropriate that this selection commission should work energetically to make sure that we diminish the influence of oligarchs in the judicial process. Is that fair too?
Yes, of course, that's fair to say. It's a huge challenge. It's a difficult question because it's very complicated to link a specific person with one name to the oligarch. If we see that a manager has been appointed to work within the oligarch's company, then we are definitely sure that the oligarch had influence on that manager. But if we are talking about public office, it will be much harder to find this link between the person and the oligarch, but we can try and identify this link, and we can try and prevent not having this influence of oligarchs in the future.
And you've indicated in response to my colleague that you've not represented any oligarchs, although that's not illegal to do that, but you've indicated you haven't been involved in that process. Is that correct, too?
Yes, that's correct. Those oligarchs who are well known, I've never represented any of them.
And in fairness to our process, I must ask you, too, whether there's any influence. In fairness, I must ask you whether there's any influence of people who are fairly described as oligarchs in the Anti-Corruption Center or any other organizations you've been involved in. Is that correct? And let me ask you that question.
No, no such influence. There has been no such influence because, first of all, we are talking about those 5 or 6 biggest oligarchs that we have in Ukraine, and none of them reside in Kharkiv. In Kharkiv, we have big businessmen. So even those big businessmen in Kharkiv have never influenced any of our procedures, any of the decisions made by our organization. All of the decisions were made by the founders, and there was no external influence. But we even check whether the information that we get was provided by someone in order to influence us. That is something that we're constantly doing, checking the information. And if I may, I will answer your previous question. I would like to add a little bit to that. I was not representing interests, but the other side was represented. The other side was the oligarch or the company that they represented.
Let me go in a different direction, please. In your opening statement, Mr. Rysenko, you said that some of the individuals that the High Qualifications Commission would be choosing for the judiciary would be serving in the year 2050 and beyond. And you don't know what the judiciary in Ukraine is going to look like in 2050 and beyond, of course. But if we were to place you on the High Qualifications Commission, of course, you would have considerable influence in that direction, would you not?
Yes, of course.
And what would Volodymyr Rysenko like to see the judiciary of Ukraine look like in 2050 and beyond? I understand there's 16 people on the commission, but I would expect you would provide some leadership in that regard. And what kind of judiciary would you be working to try to facilitate in Ukraine? What would you be doing? What would you be pushing for? What would your arguments to your colleagues be? What would your passions and interests be in terms of how to define the judiciary you would like to see?
Thank you for this question. It's a very important question. In my opinion, the challenge that HQCJ is now facing when we didn't have HQCJ for the past 3 years has resulted in many vacancies which are not yet filled. And it cannot be compared with the challenges that the previous HQCJ had. That is why I think that the first step that the future HQCJ must make is to create a team of like-minded people that will be working towards common result. That will depend on those people who will be selected. And it also depends on the work of the selection commission. It's important that you select these like-minded people.
Mr. Rysenko, can I interrupt you? Don't want to get too far away from my question. My question isn't what procedures you're going to set up. It's not whether you're going to work as a team or not. It's what would you like to see that judiciary tomorrow in Ukraine look like? How would you compare and contrast it to the judiciary of 2023 in around February? 。
I would say that the judges who will be administering justice in 2050 will be independent in their decision-making, and they will be following the law. And they will not be thinking about how their decisions will be perceived by the society or other government bodies. So they have to be independent and competent. They must be that foundation. And in addition, every member of the society will be sure that regardless of the decision made by the court, a judge is always guided by their professional competence, and that is the law, and that they are independent of any external influences, independent of the desires of government authorities or the pressure of the society. As far as specific steps are concerned, I think that HQCJ should not be an arbitrator waiting for some negative opinion from PIC, waiting for some information from the candidate. I think that we need to have this very quick interaction with civil society so that before the interview we get as much information as possible about the candidate, have as much information as possible in the dossier. We need to find all the red flags in that dossier and ask relevant questions. And we should not have any candidates that have those red flags, so that the system has only judges with integrity, so that it's a revolution of stuff in the courts. Let's call it like that.
Let me say in conclusion for the time being that I thought you made a thoughtful comment earlier about the rule of law. The rule of law does not mean that all is good in a society. It's just a necessary starting point. The law also has to be good. And law being good is not only the job of the members of the judiciary, but of course it's the responsibility of those who work with the other two branches of government too. You're distinguishing between the rule of law and the personal rule of individual judges. I thought was well taken. Thank you very much, Mr. Rysenko. Let me...
Yes, of course, I make this distinction. Yes, we have touched upon that already. The court can only follow the law, and the law making, that's the mandate of another branch of government, but that has nothing to do with the topic of this conversation.
Well, thank you again for that insight. Let me move on to my colleague, Judge Volanov.
Good morning, Volodymyr. As a follow-up question, let me ask you the following. So, in your response to the question asked by Judge Zazachny, you said that there are some positive and negative trends in the judiciary. So you mentioned well-reasoned and poorly reasoned court judgments, which tells us that you had first-hand experience with these types of judgments, both positive and negative. So as a lawyer, as a participant to court hearings, what other positive and negative trends have you experienced within the judiciary? If we are talking about some positive trends, and I believe this is very important, it's the independence of judges. It's them administering justice in a duly manner, because in recent years we've been witnessing this strengthening of independence of judges. When we started court hearings in Kharkiv, it appeared to us that it was impossible to go against the local government. But we started this practice, and the courts made well-reasoned decisions, and in most cases we won. In some cases we did not. But it became clear that the judges who made those decisions were independent. The society was expecting that lawsuits filed against the city council in the same city would not be won by us. And sometimes we could even hear applause from those people in the courtroom, and we realized that at that very moment the authority of the specific court and the specific judge was really high. If we are talking about some negative aspects, the negative thing which may be connected to the activities of HQCJ is the duration of court hearings, inability of the clients to get any kind of court judgment. They cannot get those judgments within reasonable terms because judges have this great workload. They have to postpone court hearings for a month or two. And practically this results in lack of access to justice. It seems to me that the situation could be changed if some amendments were introduced into legislation when we are talking about the abuse of rights of the parties. But the courts are forced to do that. And it's obvious that one of the parties is abusing its rights and violating the rights of the other parties. But that doesn't really have to do anything about the topic of our conversation. Thank you. Thank you for this answer. Volodymyr, you also told us that the new HQCJ had to be made of people who are versatile, of different kinds of people. So, should you be appointed as an HQCJ member, what kind of qualities are you going to be using in the work of the new HQCJ? You as a person. First of all, I will not be repeating the same idea. That is my experience of analyzing tax declarations, analyzing whether their income corresponds to their lifestyle. Number two, that's the analysis of court judgments, because the information that the HQCJ will receive, including that information from the civil society organizations, should also take into account the analysis of court judgments. Court judgments and appeals. So we should see whether it was a well-reasoned appeal or it was just an appeal made by the party that lost, trying to influence a specific judge, trying to influence their independence. Because we understand that in any case, one party is the winner and the other one is a loser. Thank you. My next question. You also told us that we need to have tighter interaction between HQCJ and PIC. Could you please tell us about any specific steps that you would take to have this better interaction? I think that we need to strengthen the communications department of HQCJ. We need to be the ones collecting information. So we can use any sources of communication. I mean, Telegram channels, Facebook pages, comments, and private messages. With regards to specific candidates. This will result in an avalanche of information, but there is no extra information that we shouldn't be analyzing. These are just the facts reflecting the reality. So I was telling you about tighter communication. when we can have some comments and Facebook pages of candidates analyzed. Without this information, we cannot reach the interview stage without having those facts that we need to check and potentially ask further questions. And if these facts are true, they should be included into the judicial dossier. In addition, the dossiers must be completed. All the e-dossiers must be completed so that the people who report some facts have the ability to check whether these facts have been included into the dossier. Thank you, Volodymyr. For lack of time, I'm passing the floor to our chair, Ivan Mishchenko. Ivan, you're welcome. Thank you. Volodymyr, can I call you an activist? It's a good question. Up until this moment, you probably could, but now that I'm a candidate within this selection, I think that should I be successful within this selection, I can no longer call myself an activist, because it will be a completely different page in my autobiography. And should I be appointed, it will be public office for me, and we should not be having activists among HQCJ members. But at this very moment, I would not want to be called an activist because I'm currently participating in the selection. So you are a lawyer, then. Volodymyr, we have the statistics, let's not debate whether it's correct or not, but we have 2,500 vacancies. Let's assume that this is the correct number. So we need 2,500 new judges in the Ukrainian judiciary, people who are professional, who have integrity, etc., etc. So they should at least meet these two criteria. And the new HQCJ in some way must fill in those vacancies. A judge or a person who wants to be appointed as a judge once they are appointed, they will have a huge workload. Most likely, they will not be working in very comfortable conditions because some of the courts were physically destroyed, including Kharkiv and Kharkiv region. Well, they will get some kind of salary. And they will be under constant scrutiny from the public. A judge will be filling out several declarations. I think we fill out 4 or 5 declarations. Maybe in the future there will be more. In addition, the environment is quite toxic because everybody is talking about lack of trust in the judiciary, and we do have this lack of trust. Could you please tell us, how are you going to convince young specialists to join this field and get on with this very difficult job? Let's assume that I'm a candidate judge who is deciding what to do after graduation and after having worked for several years at an international law firm. So I'm deciding whether to continue working as a lawyer or to pursue a judicial career. How would you convince me to become a judge? What kind of arguments would you put forward? I would break down the answer into 2 blocks because we need to find arguments both for a candidate judge and for the state. If we are talking about a candidate judge, then we must tell them that the career of a judge is the peak in the career of any lawyer, because the level of responsibility for the decisions that the judge is making and the influence that judges have on legal practice is incomparable with the work of a lawyer or attorney. So it's a challenge, but if you are successful in facing this challenge, then you can say that you've done something good in your life. That's the first thing. And the second thing, if we talk about the state, I really like the selection for the Supreme Court, when we had not just lawyers involved, not just those people who had experience of working within the courts, judges and assistant judges, but we also had different kinds of lawyers involved. And that experience was quite useful for the state. I think that we can borrow the same experience and apply it within the selection of trial court judges. Maybe not trial courts, but appellate courts, because we will engage a wider audience and they will face this challenge. And we already have this positive example within the selection to the Supreme Court when we had a competition between best of the best. So this is going to be my answer. So this is the peak of your professional career, professional challenge, and plus it should be the effort of the state in order to enhance the positive selection. Thank you for the answer. We've almost run out of time that we have allocated for your interview. So there is one more short question from Yevhen. So just this question that I forgot to ask you with regards to your motivation. You mentioned that, amongst other things, it will not be difficult for you to follow ethical norms, but you said that you are an active social media user. I checked this information. Yes, you have 2,500 followers on your Facebook page, so you're some kind of star, as is often mentioned by our chair. So 20 hours ago, you reposted a post by Ms. Tatyana Vlasova, who expressed dissatisfaction with the fact that a specific individual was awarded the title of Honorable Citizen of the city of Kharkiv, and she provided some arguments with regards to her dissatisfaction, and she was using quite strong language in her post. So, in your opinion, for a member of HQCJ, is it correct to have a social media page where obscene lexes can be found? Thank you. This is quite an unexpected question. But the problem is that I did not repost that post. I was just tagged in that post. In any case, we can find it on your Facebook page. So, if I were to answer your question, I just didn't go to my Facebook page before the interview and I didn't see that I was tagged in that post. I just need to close that feature so that people can tag me in their posts. And I believe that the use of obscene lexes is unacceptable for an HQCJ member and a lawyer as such. Thank you. Thank you. That was indeed a short question. Thank you, Yevhen. Volodymyr, your interview is coming to an end. As a rule, we give our candidates an opportunity to summarize their interview, to tell us some important facts that will be the takeaway of your interview. So the floor is yours. First of all, I would like to thank the Selection Commission for this opportunity to participate in today's interview. It's a really interesting experience, and I enjoyed all the questions asked by the commissioners. And I think I will be pondering over my answers for some time, because I'm not sure that I was satisfied with all the answers that I had provided. And the questions were much more profound than I had expected. I think we had enough time to discuss many things for me not to add anything special in my concluding remarks. Let me just address my colleagues participating in this selection. Let's follow the timeline. So the decisions made by the new HQCJ will have an impact on our future. And I think it's a great burden. The price of the mistake is high, and we have to be responsible about our duties. Thank you. Thank you, Volodymyr. That's the end of your interview. Best of luck to you. Take care and goodbye.